Not for the strong. They search for the weak, the lonely, the lost, the ones desperate to be seen. Your pain, sacred control, not love. It feels like safety, but it's a cage. Your fear is the faith. Hope becomes their power. Soul the prize. This is the warning. Trust no promise that demands your mind. No love should cost you everything. This is disturbed.
Oh boy, that thing is so scary.
I know it is creepy, but I like it.
I like it too. So if you're wondering why we're running a little bit late, Mo and I, we were watching perverted songs, videos, just so you know. But
And not
we were
our
also,
own this time.
no, they weren't. They weren't. I didn't create this, so I'm not going to show it to you. But I might give you the link to it at some point in time.
It's pretty funny, though I'm pretty sure if Friday didn't get us going to Hades, this one will.
Oh yeah, Friday. Oh, did you know that Friday I got demonetized for that?
Oh,
Yeah, Friday night. It
oh
was
no.
oh, it was just because there was a song in there that I didn't realize was in there. So all I
Oh,
did was fix the song and I got my monetization back. They can suck, you know,
oh, well,
church
that's
bells.
okay. This weekend I learned that when one gets told by I honest to God, he looks like Valhalla's dad. When one is told by Valhalla's dad that he makes his own product and then he said, I'll give you a discount on it, one should remember that this is an old veteran from the Cheech and Chong Wars. So Mo got up at 4 a.m. on Sunday and decided, my legs are really hurting. And yeah, then Mr. Mo comes down and I'm like, do you think Dairy Queen is open? And he's like, what are you talking about? I was like, I can see colors. And he's like, that's how you see. He's like, no, these are cooler colors. And he's like,
I can taste the colors.
and he was
There's
like, and I said, do you think that they would open Dairy Queens early for me because I'm really hungry for some Dairy Queen? And then I decided to be all honest. Mr. Yeah, no, apparently this Mo didn't talk to the rest of the Council of Mo's because we hide our fears pretty good, but she was like, "Oh, if I say I'm going to do this, I won't. So you need to remind me because I just don't want to do it." This is. I am like heifer. Who decided? And I was like sitting behind myself, couldn't get me to shut up.
oh my god. No, but Mo and I also talked about we're going to do Disturbed one night a month.
Yes.
And Coburger one night a month. And we'll just rotate it out every 2 weeks. So you'll still get the
Yeah.
same stuff. It's just we're gonna space it out. That gives both of us a little chance to rest. I was exhausted this weekend, as I was telling Mo, because I built my computer. Although it still looks like I'm all jittery and stuff, I'll have that fixed at some point in time. It's not the video on the that's making it all jittery. It's just my setup on the camera. That's all that's causing it.
Yeah, I've been helping. I'm like his Yoda for technical stuff. He calls me,
Yes,
he's like, Mo, where does this piece go? And I'm
yes,
like, hot glue it right there.
yeah. And if the glue doesn't work, a flamethrower works every
Well,
time.
I told him double-sided tape.
Yeah, and it did help. The double sided tape did. At least it kept my butt cheeks together whenever I was worried. So bad. No, but the computer is up and running, so I have access, and it doesn't look as bad or sound as bad as it did. It was pretty rough there for a few days, a week or two. But yeah. So we'll be doing Disturb once a month. So today's what, the 13th. So think about mid-month, you'll get
Yes.
this. And then usually around the first of the month or the last of the month, it'll be Coburger. And that way we can sort of plan a little bit better, and we're not both exhausted because we cover so much stuff throughout the week. Just like it can wear on you really quick. How are Mo's feral children?
Well, half of them are on fall break and the other half are pissed off they are no longer on fall break. So it's peace and harmony here in Mo land. It really is.
Yeah, they couldn't do it all at once. It would make
It would make
vacations
too
easier.
much sense.
Yeah. Yeah. Yeah, that would make too much sense. All right. Well, where we left off was just, like I said, we've just been going through some of these filings so you guys could understand a little bit of where the Twin Flames attitude is going into these court cases that are about to kick off. I would say next year.
Yeah.
I would say next year is about the time that's really going to start kicking off. You're going to see a lot more information coming out about it. And I don't think that they'll have the same attorney, but I think these people will probably be called in as like witnesses because they were part of the Twin Flames universe.
Yeah. And if Jeff and Shalala's, kind of strategy is to bring up the Vice article, which they can't seem to, stop talking about, they're going to bring in the Vice people. They're going to try to make this a countersuit, like, we are being persecuted because of our religious beliefs. So I would expect to see a lot of, ACLU religious freedom talk when the, Twin Flames universe comes out. Expect to see a lot of, people that are gunning for, or are supporting them to say, we're being targeted because, we're queer inclusive, or because we don't, stick up with the gender conformative norms. I expect to see a lot of that kind of stuff.
Well, and that is a possibility. I mean, that would be, but those will be outliers on what the case has to do with. Because whenever you're not only condoning, but you're creating a system inside of a group that is telling people, forcing people to change their gender. That's whenever you start running into issues, and whenever being just like, if you want to chop your junk off or add stuff or whatever it is that you want to do, go for it. There's a difference between that and telling people, dictating that you would do this, and all the while making money off of it. That's where I think that they're going to run into serious problems. And I think that anytime someone comes out, well, it's because you're not gender inclusive or some crap like that, it has nothing to do with this case. It's a distraction. And I think that should be constantly pointed out, that these kinds of things are a distraction of what the case is really about. Yeah. It's not about religious freedom. It's about somebody running a scam and stealing money from people.
Yeah. And I do wonder because I do believe he got smarter as he went, but that early time, I don't think they had any accountant. And that's going to be the part where I think they're going to get trapped in some bad things.
Right.
And it's going to come down to the same thing that got Al Capone, the taxes. They probably haven't been paying taxes. They probably did not, make the Church of Unity or whatever, correct. They probably didn't label that correct.
Right. Right. Oh, that's very good to hear, Tammy. Your adopted grandmother's funeral arrangements are almost set. Yeah, those are one of the hardest things to get all together. It's just, I know, and don't get me wrong, losing somebody is really hard, but it's like this kind of stuff that's left behind for everybody else to deal with is always like,
Yeah, and at the time you don't want to deal with any of that.
Right, right. And I will say that any funeral director that that I've dealt with or run into or have talked to, they're very understanding of this. If they're good ones, if they're they're like your local ones that have been around for decades, they probably know you and your family pretty well, and they're not out to rip people off, because there's some people they'll just rip you off. But
Yeah.
they're usually saying, this is this is what we offer, this is how we do it, take your time. They just won't rush you on it. They'll just be like, I know this is a lot, and they're very understanding. So
Yeah.
yes, absolutely, I agree with you,
Yeah.
Tammy. Good thing she's not
That's
normal pain anymore.
yeah.
So there is that. Yeah. Yeah, yeah. I can completely understand. Okay, so here we go. Twin Flames universe, or the total FU, whatever you want to call them, the ions or the ANs or the Aryans or whatever they are called. I don't care. For their reply, affirmative defenses to the counterclaim asserted by Adam Catsale and Adam Namaste. AKA Adam Namaste, DBA, Accession Express, Catsale, or Accession Express, states and alleges as follows: asserting claim against the plaintiff, counterclaim against another defendant, cross-claim if applicable. We ain't going to respond to your shit. And if we have to, we're not going to do, we're just denying it. And they do that on A and B. With respect to the prayer for relief, no response is required. To the extent a response is deemed necessary, plaintiffs deny anything. Now, they do have affirmative defenses, and you have to understand who's filing this. This is the plaintiff. Plaintiff is the Aryans, or whatever they call themselves. That probably is most fitting for them, though, because they're still white bread.
Yeah, well, that's the thing. He doesn't look Greek enough to look like Jesus from Israel back in the day.
No. Yeah. No.
No,
it just doesn't work. And he looks like a manlet. You know what I
he
mean?
does.
I,
He
I've
does.
I've known guys that look like that usually, you're going, oh, a swift wind comes along and blows you over, so you find other ways of being a douchebag.
If he was really living on hot dogs, you thought he would have at least, gained some weight like she did, but no. Of course, he might be used to living on hot dogs.
Well, I mean, in more ways than one, possibly. And basically, they say that all of this was caused by her. And then they put in, and like I said, the only reason I'm sort of skimming over this, to the extent that Catsale suffered any damages, they failed to mitigate such damages. Plaintiffs raise each and every defense available. Conclusion, they just request that they have a judgment dismissing the counterclaim with prejudice, awarding the costs and such other relief as the court may deem appropriate. And that's whenever we get into 12, which is basically saying the same thing. If I'm not mistaken, I could be wrong, is showing the same thing.
Yeah.
And the only reason I'm sort of skimming over these is because, they're just saying, no, we deny. And then, of course, we get to 22, which is their, damn it, I keep doing that crap. It's, the memorandum of law and opposition defendants Louise Cole's motion for sanctions. Now, this is where it's going to be about 16 pages. And here you go. I'll let you kick this one off if you like.
Okie dokie. Let's see. A statement of questions presented. 1. Should this court deny defendant Cole's motion for monetary sanctions against plaintiffs and plaintiffs' counsel under Rule 11 or its inherent power when 1. Defendant Cole has failed to comply with Rule 11's 21-day safe harbor provision, 2. Defendant Cole's Rule 11 is untimely, and 3. Defendant Cole's Rule 11 motion lacks both specificity and merit. And Defendant Cole's motion for monetary sanctions pursuant to the court's inherent power is underdeveloped and otherwise fails to carry her burden to demonstrate anything warranting imposition of the court's narrow inherent power in this matter. Plaintiffs
And
answer yes. Defendant Cole answers no.
okay, so here's the thing: whenever they're talking about Rule 11, and Rule 11 is only going to apply whenever you file the lawsuit. Okay, and so you have 21 days to pull that out. So the safe harbor provision, the 21-day safe harbor provision, is doesn't matter, because more than likely they didn't even follow Rule 11, because it had nothing to do with this, because that would be a 12B motion that they more than likely filed. Or if they did a counterclaim, the Rule 11, there is no 21 safe day harbor on that. And I could be wrong on this. It depends on what their civil rules or federal rules of civil procedure are. But Rule 11 doesn't apply to this, so it wouldn't matter. It's just like and I've seen these kind of pleadings before, where they plead things that they want to claim one thing, but it doesn't apply. We've seen people file things that are only apply in a civil court, in a criminal court. If I'm not mistaken, that was during the Young Thug. That's what and what, I cannot remember her name, because it all happened here in Georgia. The attorney that had to
Adrian Love or Fannie Willis?
No, it was neither one of those. It was the one that was basically bringing all this stuff up to the judicial committee, and she's like a lawyer's lawyer. She was defending the attorney in the Young Thug case that was sanctioned by the judge.
Yeah, I'm trying to remember her name. She's blonde, I think.
Yeah, and gorgeous too. I mean,
yeah.
So she was the one that was defending the attorney, and she had to explain in front of a judicial committee the difference between what was it, I'm trying to think what it was, because it was something very specific that the rules apply differently in civil and criminal. And it had to do with the sanctions for the because he wouldn't give up his source of who was sitting in the room, and leaked the information that he was having ex parte communications, and said, I can't, that's attorney-client privilege, and he lost his shit and tried to sanction him for it.
Oh yeah, I remember that.
Yeah, that right there. This is the same kind of thing. They're pleading something that doesn't matter in this. And we'll skip over the rules of all of this stuff. And I love watching people just try to spin shit here. Plaintiff, the TFU, the Aryans respectfully submit this brief and memorandum of law in opposition to the Cole's motion for monetary sanction pursuant to Rule 11. Well, in the way that motion for now, if the defendant asked for sanctions pursuant to Rule 11, that means that they're trying to pull out of this case. They're trying to leave, and they missed the 21-day safe harbor. Okay, so within those 21 days, if you continue on with the case, you can, and then after those 21 days they bail, you can apply Rule 11 to those sanctions. Okay, so that it's a weird rule, but what it does is it keeps people from and if they constantly are doing this, they let it run for 21 days, you can file a different motion. I can't remember what it is off the top of my head, but basically puts them as a vexatious litigant, which means that they create a lawsuit, they sue you, and then within those 21 days they pull out, and then they come back, and they do it again and again, and each time it's costing you money. And they want to make sure that if someone does that in Florida, I think it's more than 3 times in a 5-year period. It used to be more than 5 times in a 7-year period, but they changed that last year. So
yeah,
and it doesn't have to be for one; it's just any cases.
Well, we haven't been seeing that, coming up here lately in other cases.
No, none at all. So defendant Cole's belated motion for monetary sanctions against plaintiff and their attorneys filed over a month after this court has already dismissed the complaint against the defendant Cole. So what they're trying to do is they're trying to say, oh, we don't owe you anything. But if they responded to it within those 21 days, or they were outside of the 21 days, that safe harbor can go away. Should be similarly denied given it contains significant procedural and substantive defects. As a threshold matter, there's significant procedural basis to deny the motion for monetary sanctions. In other words, please don't sue us back. First, defendant Cole has failed to comply with Rule 11 safe harbor provision, which required her to serve this motion on plaintiffs. No, not. Okay. Jesus Christ. They're conflating the rules in the wrong way. I'm sorry. Whoever this attorney is I'm confused. Make it make sense to me. Come on, Goose.
To be fair, any attorney that has to deal with Jeff and Shakray has probably got a few screws loose.
Okay. So from what it says right here, defendant Cole made a motion for monetary sanctions pursuant to Rule 11 in this. Okay.
Yes.
And what they're saying here is, and their attorneys filed over a month after this court already dismissed the complaint against defendant Cole. Okay. As a threshold matter, there's significant procedural basis to deny. First, defendant Cole has failed to comply with Rule 11 safe harbor provision, which required her to serve this motion on plaintiffs 21 days before it was filed. No.
How can you serve something 21 days before it's filed?
Okay. You can send a letter to them.
Okay, that makes sense.
Now it makes sense. What they're saying is so yeah, they could have standing on this because it's required that you notify them that that you're going to be within the 21-day safe harbor so that you can drop this filing. And they never did this. So they have to serve the motion to them, okay, although it's not filed in the court yet.
All right, that makes sense.
Okay. Now, some states, I don't know this particular state, some may not require that. In federal court, maybe. This she admits she did not do. Okay, so she says she did not do, whether formally or informally. The motion is also ultimately, given it was filed after dismissal and after judicial rejection of the alleged offending contention. Similarly, the court should not issue Rule 11 sanctions as defendant Cole requests on its own initiative or its inherent power, or it has not issued in order to show cause. Finally, the court should not exercise its inherent power to issue monetary sanctions. The premise of defendant Cole's post-dismissal motion for monetary sanctions is that plaintiff's filings of this complaint is sanctionable ipso facto, because the court later disagreed with plaintiff's legal arguments for Cole's personal jurisdiction in Michigan. Your plaintiff's counsel's legal arguments for jurisdiction, while not agreed with, were not objectively unreasonable nor advanced for an improper purpose. This is especially true here, where the court directs the parties to later supplement their fully briefed motions on the basis of a recent Sixth Circuit decision blessing. Why? What? I don't. Did they sneeze?
Well, yeah. I mean, are they blessing people to bring ridiculous lawsuits?
Or maybe that's the court case, but I don't know anything. They didn't cite it correctly if it is.
Yeah, that's not a proper citation for a court case.
Yeah, it's weird. Concerning personal jurisdiction over allegations of false statements on the interwebs, and decided the party's motion on the basis of holding in that case, which was decided over 8 months after plaintiffs filed the complaint that Cole contends was sanctionable. Well, being wrong is not tantamount to sanctionable behavior. Filing a frivolous lawsuit could be. Well, and and defendant Cole already received the benefit of the ultimate sanction, dismissal, and declination to transfer venue. Well, that's not a sanction.
No.
Dismissal
Sim-
is not a sanction.
Simply put, there's no evidence of the kind of something more than the filing of the complaint to warrant the imposition of monetary sanctions on a routine motion to dismiss. To issue monetary sanctions months after dismissal on the basis of a pre-answer procedural motion without any consideration of the merits of the claim and where personal jurisdiction can be waived would be unprecedented given the absence of the kind of litigation conduct representing bad faith on the part of the plaintiffs or plaintiffs' counsels required to impose such sanctions. In short, no additional monetary sanctions are warranted. Defendant Cole's attempt to have the court to rely on plaintiffs' irrelevant post dismissal out of court statements to impose sanctions on plaintiffs' counsel who had no knowledge or control over such statement. So Jeff and Shakray Cray popped their mouths off after it got dismissed.
Yep.
Should be rejected. Accordingly, plaintiffs respectfully request this court to deny defendant Cole's motion for monetary sanctions in its entirety.
Well, I mean, it raises an interesting question, because you shouldn't be sanctioned for popping your mouth off after you're like, we won. I mean, that shouldn't be sanctionable. But that's not why they sought to have those sanctions imposed. That's something for the court to decide. I mean, they're making a good argument here. I'll say that they are making a good argument, except they're adding things in there that are irrelevant, such as plaintiff's irrelevant post dismissal out of court statements. Those have nothing to do with this,
No.
because you don't give reasons in court of law, unless the judge is asking for a reason for it. Does that make sense? Like, just because your
Yeah.
fifis got hurt doesn't justify, any action by the court whatsoever.
But I'm wondering if Jeff or Shalia threatened them, like, we'll get you again or we'll refile. And
That
I don't know.
maybe what they said, because that was one of the threats that I received from Lips Federigos or whatever her name is, that she wanted that, it's like, oh, I can file this again at a later point in time. It's like, that it should be dismissed with prejudice. If you're going to file a lawsuit that's clearly frivolous and clearly doesn't state any cause of action or any reason or anything behind it except making crap up, then the judge should have just, I mean, I understand why they're doing that, because maybe you didn't have your facts in straight or whatever. But, from the get-go, it's making stuff up. I mean,
Yeah.
it was targeting people just for the sake of targeting them, because you wanted to get them to be quiet about certain things.
Yeah.
Which is, there's different laws that you need to abide by, and just commenting on people's videos is not, court of law is not going to say anything about that.
No.
Me commenting on what people are filing, there's nothing illegal. Adelson got her sentenced life without parole.
Oh.
Who's Adelson?
Well,
I'm sorry, maybe I'm out.
Adelson, Donna Adelson. So she's the one with Wendy, and basically the entire family got together to take out their daughter's ex-husband because he
Oh,
was too devout and too devoutly Jewish and wouldn't let her move back in with mommy and daddy.
oh, so they deleted him over that?
Yeah. Yeah.
Mm.
They actually laundered the money. They legitimately washed it and stapled it together. The money that they paid the hit people was damp.
Do they think money is dirty or something? Does that?
I I don't know. I think this is the first time they tried to crime, so she was laundering the money so it would be undetectable. Yeah.
We are
Yeah.
not, they don't have a full bag of rocks in their head, I guarantee you.
No.
Argument: this court should deny motions for monetary sanctions under Rule 11 because defendant Cole failed to comply with the safe harbor provision, which I agree. If they didn't send that letter ahead of time, then there's that possibility. As an initial matter, defendant's Cole motion for Rule 11 sanctions is procedurally defective. Specifically, defendant's motion for monetary sanctions fails to comply with Rule 11 C2, Federal Rules of Civil Procedure. Okay, so it is federal rules of civil procedure, not just state specific.
Well, and he would probably have to be federal because if this is the same person, I think this person was also out of state.
Yes. Cole, none of them that they sued were in the state of Michigan or had any ties to the state of Michigan.
Yeah.
And that's why they brought it federal, because state's a little harder to do on these. Rule 11 contains a safe harbor provision stating that Rule 11 motion must not be filed or be presented to the court if challenge claim was not drawn or appropriately corrected within 20 days after service. So it's after service. Sanctions under Rule 11 are unavailable unless the motion for sanctions is served on the opposing party for the full 21-day safe harbor period before it's filed or presented to the court. Reversing grant for Rule 11 sanctions where the defendant failed to give the plaintiffs 21-day notice before filing. So that's all they're quoting, is where the same thing has happened before. We're reversing the grant of Rule 11 sanctions where a defendant failed to give them the 21-day notice.
Yeah. And that might be the, end all be all to it. A lot of court is procedural. You have to do things and you can't make excuses. You might have, hey, my entire family, was attacked by a bear and I couldn't get them served. But, the court doesn't care. You either get it in by the time it's due or it doesn't count.
Well, and of course, we've been looking at another court case that the attorney passed away. And now here's where it becomes really touchy, because you don't want to come after an attorney for sanctions, but there are procedures that if an attorney is behaving in such a way that becomes sanctionable, you can file to basically go after their estate. It's cruel, but sometimes that's the only relief that you might be able to receive out of somebody's bad behavior before they passed away.
Yeah.
Another thing is very incumbent upon that person that they were representing to find new legal representation almost immediately. So that way they can file all the proper paperwork. They can make sure that they've got a notice that they've noticed. And if you're going to represent yourself, then you have to file almost immediately. So that way you can make sure that the court is aware of the situation, that the situation has changed, or, you could have an attorney that was in a bad accident and is now in a coma. All of these are legitimate reasons to file something with the court and say, hey, this is a situation that's going on with my attorney. Can you give me just a little bit more time to seek new legal counsel? And you do it immediately. If you wait, if you've known about it, because you've got something that happened back in January, and here it is, August, and you're saying, oh, well, maybe I should respond because now I've got creditors knocking on my door. That's not the time to do it.
No, I mean, and I've had this happen in my life. I had some court cases going on when my first husband passed, and I had to let the lawyer know. And even though he was, representing me pro bono, he had to withdraw the case. I mean, he was like, yeah, I'm going to need the death certificate and everything so we can drop the case. And I was being 24 and dumb, and I was like, why? And it's just procedural.
Yeah.
I mean,
yeah.
so,
And that's why attorneys get paid so much damn money, is so they follow the procedures. Exhausted, but doing okay. Good to see you. Good to see you. You're late, but you're here. Good. Hey, Mary, anytime is a good time. Did you read this part right here?
let's see. Here, defendant filed a motion seeking monetary sanctions pursuant to Rule 11 with the court on April 30th, 2021, without first serving it on the plaintiff's counsel and without waiting 21 days. Defendant has provided no evidence of compliance with Rule 11's safe harbor provision, nor can she. Failure to abide by these requirements is fatal to defendant's Rule 11 motion seeking monetary sanctions. Now, because defendant Cole did not serve plaintiffs her motion for sanctions 21 days before the motion was filed with this court, Cole's motion is procedurally improper and thus subject to denial.
And
Yeah.
you can just skip over those things because those are just
Yes.
the sidings. The motion for monetary sanctions under Rule 11 is likewise untimely. Moreover, the serious untimely is axiomatic. Thank you. That if defendant was required to provide plaintiffs with a 21-day safe harbor period in which to withdraw the offending papers, then it must be the case that they be afforded an opportunity to withdraw the papers. That makes sense. And it basically says a Rule 11 motion cannot be made unless there is some paper, claim, or contention that can be withdrawn. It follows that a party cannot wait to seek sanctions until after the contention has been judiciously disposed. Sanctions under Rule 11 are unavailable unless the motion for sanctions is served on the opposing party for the full 21-day safe harbor period before it's filed with or presented to the court. The service of filing must occur prior to the final judgment or judicial rejection of the offending contention. So you can't, and they're correct in this. So you can't file if you don't give them that opportunity you can't wait until it's already been adjudicated. Like it's like coming back and then say, oh, well, what about this? Because then it's just a tit for tat. I mean, you should have thought about this beforehand.
Yeah, and that's the other thing that having a lawyer is so good, because they know all of these safe harbor things, because again, so much of this is procedural, and it's, you're not dumb for not knowing it. This is an entire language and kind of, world in and of itself. So you need to get people that know the rules, know how to talk, and know how, because that's, the other thing they did to kick them or shoot themselves in the foot is they put a very emotional, very vengeful letter out there prior to getting a lawyer. So,
right. Yeah. And this is why whenever you're doing these kinds of things, the attorneys, you also have to understand, like my wife does civil work. She doesn't know anything about criminal. Like she would not be able to do something. She could, because she would have so much catching up to do, because there's certain steps that you have to take whenever, for example, you're filing a lawsuit or you're responding to a lawsuit. There's certain things that attorneys that have been doing these kinds of cases long enough, you talk to a general practitioner of law, they may not know these things. Someone that practices let's say, that they're a closing attorney. They would never although they're an attorney, this isn't their expertise. Now, in a closing, they have certain procedures that they have to go through constantly. And those are almost like a verbatim kind of document that's going to come out. It looks very boilerplate, and you'll see it in almost every single one of their filings, but it's going to say all the same things. It's going to have all the steps that you do that. Like we do a lot of quiet title actions. So we have certain things that have to be filed with court in a certain way and have a certain language in there, cite certain provisions, all these kinds of things. And then you file it with the court. The only thing that's changed on most of these is just the name and ID, parcel ID. Those are the only things that'll change on it. That's not the case in civil, because that's the way it is in civil. I would assume it's the same way in criminal, that they have those same kind of boilerplate answers. You're just changing the name of the parties.
Yeah. And a lot of times you're paying for lawyers, like for criminal cases, you're paying for them because of their relationships with the court. Usually they know, okay, well, this judge we do this strategy. Oh, you pulled this judge where you're kind of screwed, but I think we can play it this way and this way.
Well, and I think that was the disadvantage the attorney had that was representing Sarah Boone is, he's coming into
Yeah.
a court he's never been in, dealing with a judge he's never talked to, and trying to, file things, and the judge just was throwing him out left and right, saying, no, this bears no relevance.
Yeah.
This is not applicable in this case
Well,
whatsoever.
but also, if you're going to just, parachute into a case and the judge has written a 37-page, why the hell Sarah doesn't need any more extensions,
Yeah.
and it's clearly written in there that even if Sarah Boone gets a lawyer for some reason to appoint or to, cover her, that there will be no continuations. I mean, you should read what the judge is doing in your case and realize how no nonsense he is, because I
Yes.
think he wasn't aware of how badly Sarah had behaved.
Right. Because he was only hearing, and this is also common with YouTube, kind of court cases that we follow, is if people are hearing only one side of a court case, and you see the same thing that's going on with Koberger, people are hearing one side of the case, but they're not listening to the other side of the case or viewing it as an overall of what's actually happening in the case. Then that's why we were getting some of these people that would come in and just like, how can you say that Koberger is guilty? I mean, what rock did you crawl out from under to think that he did not plead guilty to all counts? Okay, that there's like, and to try to explain this to people is like, I'm slapping my head, just going, okay,
Yeah.
I don't have time to sit here and go through every single reason why. But if you haven't done that research on your own, then you might want to just shut up.
Yeah, well, and that's the other thing. I like a good, conspiracy theory as much as the other person, but
Yeah.
the reason I think he's guilty is because he pled guilty.
Right.
Like, I didn't have a dog in this, fight. I really didn't. But dude sat on camera and said, I is guilty. And so I'm going to believe him, just like Oprah said.
Yeah. In my opinion, you're a fool if you go to court without an attorney. No, that's not always true. I mean, you usually won't need an attorney for small claims court, because those are going to be pretty basic, and the judges will give a lot of leeway on those kinds of things. Even in a criminal case, it's not always necessary to have an attorney, but you need to be competent enough to understand what the judge is saying. Well, we see a lot of that happening with the soft sense. It's like, you may be competent, but you're not competent as you think you are.
No.
Here, allegedly offending paper is the complaint itself, filed on June 2020. On March 23rd, 2021, the court granted defendant Cole's motion to dismiss for lack of personal jurisdiction. The case against Cole had long concluded, and the judicial rejection of the offending contention, the grant of the motion to dismiss, occurred over a month before defendant Cole filed this procedural improper motion. So, yeah, I mean, the attorney's right in this. I mean,
Yeah. And that's the other thing is, you're probably just out this money. Unfortunately, your lawyer is there, and maybe you can write it off as a loss. But
yeah,
I mean, the person that, got their claim dismissed doesn't have to deal with them anymore.
right.
And I mean, as much as you want to sanction, sometimes, you get out and that's all you get out of this.
Yeah,
Is that you're no longer involved.
right. And sometimes that's the blessing in disguise, where, you're just like, cool, this is over. I don't have any time to waste my time on this crap anymore.
Yeah.
The motion for monetary sanctions. We'll go ahead and read that one.
Well, let's see. As another matter, Defendant Cole's motion does not describe with any specificity the alleged offending behavior or contention to be remedied, withdrawn, or otherwise is found as frivolous. Indeed, she asks the court to sanction both plaintiffs and plaintiffs' counsel jointly and severally in the amount of her cost of defending plaintiffs' claim or action in this forum. However, other than referencing plaintiffs' adjudically economic choice to proceed in a single action against multiple defendants in the forum of their domicile, Michigan, Defendant Cole makes no attempt to point out which paper, which claim, nor which contention is allegedly so frivolous or so harassing as to be sanctionable in and of itself.
Well, and the whole thing. I mean, I guess it's hard whenever you're saying the whole thing was contentious, frivolous, and done to cause me grief. I mean, because while you might be able to claim that, the court doesn't care.
Yeah, and it's hard to prove that. I mean, unless you have, the book of premeditation and them on, recording saying, we totally did this just to scare these people. We have no merit in this case. It's going to be really hard to prove that what their intention was.
Well, I don't know. Their letter sounded like it was.
Well, I mean,
their
yes.
cease and desist letter.
True. But I mean, and had the defendant said, okay, this is the letter I was sent. From the moment I got this letter, this angry, we will pursue you both criminally and, civilly, all this. My emotion, I have been unable to work. I have been, anxious, and they had a lawyer to do this, she might have been able to get costs back. But
well, and then you run into the other part of that, because if you're filing something like that, and you're claiming emotional distress, all those kinds of things, then you have to show proof of that emotional distress.
Yeah.
And that's more cost to you. Plus, they have a chance to basically question them about these kinds of things, and that might get a little bit too personal for some people, where they're just like, yeah, you don't need to know my personal life. You don't need to know that I've got a drinking habit or a weed problem or anything like that. So I won't claim emotional distress.
I mean, honestly, for Defendant Cole, this is probably the best outcome that could have happened. Their claim, the plaintiff's claim, has been seen as baseless, and they lack the jurisdiction. Now, there's always that lingering fear in the back of your head, if it wasn't, dismissed with prejudice, that they can try to come back and, figure out how to do jurisdiction on you. But don't they have like 26 different people on this particular?
This one here, I think a lot of them are AKAs, and I'm on page 9. No, that it's just Misty Warner or Burchnell, from Louise Cole from Arizona, Gregory Abbott, Miguel Abbey, and Andrea Scott.
Oh, okay.
So not a whole lot on this particular one. And I was at page 9. There we go. And now, Defendant Cole now calls this litigation based. So we already read that, didn't we?
Yeah.
At no point did she challenge it. Okay.
Yeah.
Of plaintiff's argument was direct response to Defendant Cole's suggestion to her motion to dismiss that the claims should be brought in Arizona. Plaintiffs are free to pursue their claims and litigate this matter on the merits in Arizona, a forum that possesses personal jurisdiction over Ms. Cole. Well, that's a nice play right there, saying if you want to continue this on, we will fight you in Arizona too. Plaintiffs are not prejudiced by bringing their diversity action in the proper venue. For Defendant Cole is to now claim that the court's response to plaintiff's transfer request as Defendant Cole's apparent invitation provides a basis to deem any other conduct in the context of this litigation was Rule 11, where the sanctionable behavior is unavailing. And I like that they're using words that are, not so touchy-feely.
Yeah. Even where defendant Cole's concerns to be a post hoc attack on merits, that is no basis to issue monetary sanctions under Rule 11, when the best remedy for such attacks would be be same in the result of other motions, like the one defendant Cole made, Rule 12, pre-answer motion to dismiss.
Yep.
This is well settled that a Rule 11 motion is not the place to test the legal sufficiency or efficacy of the allegations in the pleading, because other motions are available for those purposes.
Right. So
So,
that is pretty important right there. Saying that, there's other motions that are available for these purposes, and using Rule 11 as a bludgeon is not going to, should courts don't rule favorably on this.
yeah.
And the Rule 11 motion is grounded on matters that go to the merits of the party's dispute. It implicates Gluck's subjective actions. And to this extent, Rothenhouse motion raises issues as just basically giving the legal standards behind that. The court should deny defendant Cole's motion for sanctions under its inherent power because no sanctionable behavior occurred at this threshold, failed to develop any legal or factual basis for monetary sanctions under the court's inherent power. In fact, defendant Cole only drafted one short paragraph in passing about inherent power by merely citing two cases. Cole did not develop any argument nor incorporate any facts in this paragraph. That does happen.
Let's see. Having failed to mention and much less analyze any of the factors the Sixth Circuit tests regarding rare imposition of its inherent power to issue sanctions, defendant Cole mentions this court's inherent power in only the most perfunctory way, quote, regardless of the authority used to support an award of sanction, defendant Cole requests that this court enter an order awarding monetary sanctions. Now, this collection of conclusatory statements does nothing to A, provide the court a basis to consider defendant Cole's request, nor B, provide plaintiffs an opportunity to sufficiently address what apparent authority she claims warrants the court's use of its inherent power. Thus, on this basis alone, the motion should be summarily denied.
Most definitely. Even were the court to consider that inherent argument, it still fails on the merits due to the potency of the court's inherent powers in granting this award. The Supreme Court has cautioned that the court's inherent power should be used with restraint and discretion, which I agree before. Because, the last thing you want to do is have in a court, become a one-sided referee. Just because we don't like somebody that the court just inherently goes on the attack. And I showed that hilarious video, I think it was Friday, where the judge is saying, it's like, not only after you die, we're gonna file an attempted escape, and you're gonna serve another 200 years, and you know.
Well, and that's the other thing. Lawyers are held to a certain amount of, or certain code of ethics, but we don't want lawyers to have to always worry about, okay, now I'm facing sanctions. If we make sanctions something frivolous that, anyone can say, well, I didn't like the way that they acted, or he was kind of smarmy, they have to be saved for the most, over the top, sanctions case. Like that judge that we watched that one Friday that's like, tell Mr. King to pack a toothbrush.
Yeah.
I'm sure he doesn't go off on defense attorneys all that often, but when he does, he makes it count. And that's why we can't, imagine the frivolous lawsuits, and then imagine frivolous, sanctions lawsuits on top of that.
Well, or if, and that's in that case, you also had an attorney that it was consistent behavior that the judge is going, I if this was just a one-time kind of thing where these mistakes were made, no big deal. But there's consistent behavior coming from your law firm that is basically acting as a public defender, receiving state funds, and they're not even seeing their client in months and months and months. That's not that, and so we can't have that. And so he should be prepared for sanctions. Now, if it's a one-off and a judge comes off like that, you might be like, Judge, that's using your inherent power to punish where it just extends beyond. I've never seen you before in this court. This is not common for me. Things happen, people fall through the cracks all the time. And they could easily appeal something like that. But this judge is like, this is pretty consistent, putting it on the record. So it's not just, you can
Yeah.
reference back. And this is another thing that people don't understand, that, they want to make sure that, and this is happening recently, where they're trying to object to having the video recorded. Okay. The reason why you want to do this is because, for one, you don't want everybody being able to go back and reference and getting the intonation and the actions of somebody that's doing these kinds of things. And especially the person that is known to have bad behavior in a court. The people that should be having this shown are usually the ones that are fighting against having video depositions, those kinds of things. There's a reason why courts are more and more starting to allow those kinds of things to happen, because it also gives context. Now, words can be one thing, but as you've seen from reading court deposit or reading through a deposition, like, you can change what the tone and intonation is of what somebody's saying to mean something else.
Yeah, it does. I mean, what was that old joke? Like, or I think it was Ricada, like, the conversation you use with your wife could look really bad on paper. Like, Mr. Mo, I was wearing pigtails this morning. Mr. Mo's like, hey, come on. And I'm like, go away. And then, I mean, that could look really bad if it was only Mr. Mo, like, well, she had pigtails on, and I was like, hey,
Exactly. So I mean, those kinds of things change context, and I think it's it's becoming more and more important to have video evidence of bad behavior. Or even good behavior. And I would think that people would want to have this more, because then it can also give context to what the judge is saying. Because the judge might be saying something about the law, but he may be doing it in such a horrible, bad way that, and a perfect example would be, as you and I covered Judge Grudge. That would have been a perfect example. If you just read what he was saying, you'd be just like, yeah, I don't understand what the problem is with this. But once you see the way that he was giving her legal advice from the bench, you're like, that's inappropriate.
Yeah.
It really puts it into context of everything. And sometimes the transcriber doesn't get all of the, especially people who are talking over each other. They'll just put down background noise or something like that because they couldn't quite get what they were saying. Assuming arguendo that the court could isolate counsel's objectively reasonable decision to file in particular form against a non-resident, it's just basically talking. So that is, I believe, a court case, and this is the second time I've seen the Sixth Circuit's decision in Blessing. But here's where a court might like slam them, because that's done improperly.
Yeah.
It's cited improperly. And this is just basically the same thing of jurisdiction. And this part's a little bit boring, and that's why I'm scrolling down through it. And it just basically says that dated the 14th of May, 2021, that they're basically saying, they should just drop this particular piece.
Yeah.
And then this is their response to that. We get to see what the argument is, and we'll go through a little bit of this. And here it goes. And I'll zoom in a little bit and let you kick it off.
Okay.
How you doing?
I am doing okay. Let's see. Legal argument: this court should impose monetary sanctions upon the plaintiffs and their counsel under Rule 11, or by its inherent power when, by plaintiffs' known admission, 1. The purpose of initiating the litigation in this forum was to increase defendant Cole's litigation costs. 2. Plaintiffs posted a statement subsequent to this court's dismissal threatening future litigation. And 3. Plaintiffs' statements indicate that they have abundant funds to continue litigating this matter. And that's so they popped off and sent something to her, is my
Yeah.
guess.
Well, it's that initial letter that they said. No, but it looks like they did post a statement subsequent to the court's dismissal threatening future litigation.
Yeah, so
Oh, that's not good.
let's see. Defendant Cole, after reviewing the authorities cited in plaintiff's brief in opposition to her motion for sanction, agrees with plaintiff's analysis regarding this court's authority to issue Rule 11 monetary sanctions in this case, and withdraws that issue as a result. This court's inherent power to sanction is an independent basis to punish plaintiffs' bad faith action in filing this case in an objectively improper forum for the purpose of increasing defendant Cole's litigation costs. Now, plaintiffs, prior to filing their complaint, stated their intent to file in Michigan to increase the litigation expenses borne by defendants, including Miss Cole.
That's
Quote,
true.
"We will subpoena you all to courts in Michigan where you don't live, and you will have to pay travel expenses, hotels, food, court fees, lawyer fees, in addition to the money we will sue you for." Yeah, maybe don't send letters before you get an attorney.
Yeah. Yeah.
Let's see. In fact, this court acknowledged plaintiff's bad faith conduct when declining to transfer venue to Arizona, defendant Cole's home state. Here, the court finds interest of justice does not warrant transfer under 28 USC subsection 1404A or 1631 in light of plaintiff's apparent bad faith in bringing this action in an improper forum to increase the cost of litigation for defendant Cole.
Yep. And that's exactly what the court said right there. Court acknowledged plaintiff's bad faith conduct when declining to transfer to Arizona. So the court already ruled on this. And let me see, I think I have document 18 here that shows this, which, nope, that's a wrong document altogether. Sorry, wrong court case. Give me just a second.
Okie doke.
I was like, oh, that's document 18. No, that has nothing to do with this case whatsoever. And like idiot. Well, sometimes I do these kinds of things. Let's see here. 18 is right here. Order and order granting defendant Louise Cole's motion to dismiss plaintiff's complaint for lack of personal jurisdiction. And down here, so it is going into what the court said. Yeah, and the court we'll go over this document here after we're done with this one. And it says, and I'm scrolling down towards the end because that's where it's going to be. Finally, plaintiffs also request that the court transfers the matter to the District Court of Arizona. The court determines its personal lack of jurisdiction over defendant Cole. When a district court lacks personal jurisdiction over defendant, the court shall, if it is in the interest of justice, transfer such an action or appeal or other such court in which the action or appeal could be brought at the time it was filed or noticed. It is within the sound discretion of the circuit court whether to transfer in the interest of justice or dismiss the case, unless evidence exists the case was brought in the improper venue in bad faith, or to harass or defend the interest of justice generally requires a transfer. Here the court finds that the interest of justice does not warrant transfer under 28 USC. Apparent bad faith bringing this action in a proper form in order to increase the litigation costs for defendant Cole. Additionally, plaintiffs have failed to identify any prejudice. The court finds none. So they're arguing the wrong thing here, because the court's not finding any prejudice and the court finds none. This case is in its infancy. The plaintiffs do not suggest a statute of limitations will preclude their claims against defendant Cole in the proper forum. For these reasons, they declined it. So they're citing their response wrong here. Court finds interest does not warrant transfer. And it doesn't say there in light of plaintiff's apparent bad faith bringing this action. So yeah, I'm looking at that. It's not, that's not what it says.
No, it says that it doesn't seem like it has the prejudice or
Oh,
they
here it
have.
is. What it looks like is they're citing this right here in
Okay.
light of but it's no, they are right. In light of plaintiff's
Okay.
apparent bad faith in bringing this action in an improper forum in order to increase litigation costs for defendant Cole. But it also didn't warrant transfer because of this. I mean, it said that's not a good reason to do that.
Yeah.
Okay. This court can exercise its inherent power to sanction irrespective of whether there are available sanctions under the rules. And the Supreme Court and Chambers, blah, blah, blah. We discern no basis for holding that the sanctioning scheme of the rules displaces inherent power or to impose sanctions. These other mechanisms are not substitutes for the inherent power. The inherent power extends to a full range of litigation abuses. And if you want to read the next paragraph.
Okay. The inherent power of the court to sanction a party with assessment of attorney's fee is triggered when the party has acted in bad faith, vexatiously, wantonly, or for oppressive reasons. Now, choosing a forum for the sole purpose of increasing your opponent's litigation expenses is acting in bad faith for oppressive reasons. This documented bad faith motivation for choosing an improper forum is the quote unquote something more required to warrant sanctions. The court must find something more than a party knowingly pursuing a meritless action, such as filing a suit for improper purposes.
True. Plaintiffs urge this court to adopt a narrow interpretation of its own inherent powers to sanction bad faith conduct, relying on three-part test from this case, which provides that finding of bad faith requires the claims advanced were meritless, that counsel knew or should have known this, and that the motive for filing suit was for an improper purpose. More specifically, plaintiffs argued that this court is only able to sanction litigation misconduct if the underlying claims are meritless. Not so. If this court construes the first prong of this test as narrowly as plaintiffs urged, the court would be incapable of using its inherent power to sanction procedural misconduct, which I agree. The court's inherent power to sanction is supposed to be malleable to accommodate all manner of litigation abuse, not just some. This court should refrain from artificially limiting its inherent authority.
Let's see. Plaintiff's counsel attempts to extricate himself from personal liability for his choice to file his client's case in an objectively unreasonable forum is unpersuasive. The Calder effects test was well settled at the time of plaintiffs filed their complaint, and Blessing did little to alter that personal jurisdiction analysis, posting her opinions about plaintiffs to social media and cooperating with a Canadian news agency in the reporting on the plaintiffs from her home in Arizona was not conduct expressly aimed at Michigan for purposes of limited personal jurisdiction.
And then
The
start right
defendant
there.
must purposely avail themselves of the privilege of acting in the forum state. Now, the only connection Michigan has to this state or this case is that the plaintiffs reside there and have their principal office for their internet business. It is not that the complaint was brought in this forum in and of itself that renders the action sanctionable. It is that the plaintiffs expressly stated their rationale in bringing the complaint in an improper forum was to increase their opponent's litigation costs as a punitive measure for speaking out against them. The imposition of sanctions using the court's inherent power serves the dual purpose of vindicating judicial authority and making the prevailing party whole for the expenses caused by his opponent's obstinacy. Ms. Cole is asking this court to make her whole.
Request relief. Defendant Cole respectfully requests that this court enter an order imposing sanctions upon plaintiffs and their counsel, jointly and severely, in the amount of $16,581.85. That amount is the total sum incurred by defendant Cole to defend this action, including attorney's fees, costs, and expenses. And that was submitted by the Wolf Law Firm. And I just want to make sure that I had stuff. Yeah, it was just the rest of it's just a certification.
Oh, okay.
Yeah, and it's it's nothing. It's just basically saying that right
Yeah,
there.
so just to find out that there was no personal jurisdiction cost nearly $16,000.
Yeah, yeah, that's drastic. If you really think about it, that's not something that at this point in time in 2020 you could have bought a good used car for that amount.
Yeah,
You could have taken care of rent for what, 4, 5, 6 months.
yeah.
This is, and you're talking about somebody that probably doesn't have a whole lot of money,
No,
to scratch together.
no. So, I mean, and again, Jeff and Shalia kind of shot themselves in the foot because all of this is in writing. There are multiple copies of them basically saying, "We are going to bring you the pain. We are going to bring you all the pain. We have all the money and we are going to use it to cause you distinct and total pain."
Yeah. And we plan on doing this in the most brutal way that we possibly can. Now, as much as all of these kinds of motions that come about because of that, the judge did rule on this in the end, and it is via an order denying motion for sanctions.
Okay, introduction. Plaintiffs are Michigan residents who run a set of organizations devoted to spiritual wellness, relationship guidance, and self love through connection with your twin flame or true love. Ooh. After the defendants began posting purported false statements about the plaintiffs' businesses on social media and repeated these falsehoods to a Canadian reporter, plaintiffs filed an instant lawsuit alleging defamation, tortious interference with contractual relations, and civil conspiracy against numerous out-of-state residents, including defendant Louise Cole, an Arizona resident.
On March 23rd, 2021, after briefing and an oral argument on defendant Cole's motion to dismiss for lack of personal jurisdiction, the court granted her motion and declined to transfer the action to the District of Arizona, concluding the interest of justice did not support transfer under the statute. Here, the court finds blah, 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 and bringing this action in proper form other and increase the litigation costs for defendant Cole.
Now before the court is defendant Cole's motion for sanctions filed on April 30th, 2021. Defendant initially sought an award in the amount of $16,581.85, but now moves for an award of $19,069.42 in sanctions, which represents attorney fees, costs, and expenses incurred by the defendant in defending this action in this improper forum. Now, plaintiff filed a response in opposition on May 14th, 2021, and defendant filed her reply on May 21st, 2021. Plaintiff filed her supplemental brief seeking a higher sanctions award amount on October 19th, 2021.
Now, upon review of the parties' submissions, the court concludes our oral argument will not aid in the resolution of this matter, so I'm not even going to listen to you talk. Accordingly, the court will determine the defendant's motion for sanction on the briefs. And so they're just going by the briefs they submitted. Those two things that we read you was what they would consider the briefs. For the reasons that follow, the court denies the defendant's motion for sanctions under the law and analysis. I'll let you.
Plaintiff moves for an award of sanctions pursuant to this court's inherent authority. District Court has the inherent authority to impose sanctions upon any person who, quote, willfully abuses judicial process or otherwise acts in bad faith. To impose sanctions under its inherent authority, a court need only find the claims advanced were meritless and that counsel knew or should have known this, and that the motive for filing the suit was for an improper purpose, such as harassment. In the Sixth Circuit, a court need not find the conduct sanctionable under any other rule or statute to apply its inherent powers to impose sanctions. A district court may impose sanction jointly or severally against a party and his counsel.
Now, defendant relies on two statements made by plaintiffs in support of a request for sanctions. Well, one before the complaint was filed, the other after the case was dismissed against Cole. First, defendant directs the court to plaintiff's March 2020 cease and desist letter, wherein plaintiffs warned the defendants if they did not retract their statements made to the Canadian news media, the plaintiffs would subpoena all you sons of bitches in court to courts in Michigan where you, in a reply, blah, 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 don't live. And you'll have to pay travel expenses, hotels, food, court fees, lawyer fees, in addition to the money we will sue you for. Additionally, defendant denotes that after the court granted her motion to dismiss, the plaintiffs posted the following statement to their website. Thank you, haters, Vice, Vanity, and Fair. We reserve the right to take up our lawsuit again anytime we deem it appropriate or necessary, and will continue to collect any evidence which would build that case against you.
Now, based on these statements, defendant argues plaintiffs have admitted their bad faith and purpose in bringing this lawsuit in a form that was to drive up litigation costs for defendant Cole. Here, the court cannot conclude without more that the plaintiffs attempted to dredge up extra litigation costs for defendant Cole. Indeed, the court's decision to decline the transfer or to transfer the case to the district court in Arizona was based on the plaintiff's, quote, apparent bad faith bringing action in an improper forum in order to increase litigation costs for defendant Cole. Now, when considering the propriety of imposing sanctions, the court must consider plaintiff's statements in light of the complainant's allegation that they were harmed business owners. Moreover, the plaintiff's complaint alleges that they were that they were untrained in law and federal court jurisdiction. Yeah, but untrained, just because you're a dumbass doesn't mean you're that being
Wrong.
said. Yeah, their statements therefore can also be construed as a poor attempt to scare defendants about litigation costs generally, particularly when laypersons would not necessarily know they can't file the suit in the court closest to their home.
Now, similarly, the court can't conclude on this record that the counsel's arguments in support of personal jurisdiction were meritless, nor can it find that counsel's arguments were objectively unreasonable. In fact, the court directed the parties to submit additional briefing on the issue before reaching this ultimate conclusion that it lacked personal jurisdiction over defendant Cole. This was a brief action that was resolved with a single motion. Plaintiff may have asserted arguments that were ultimately unavailing. However, it cannot be said the case was litigated in bad faith. So the judge is making a very good, and you know, whenever I first saw this, I was like, well, that shocks. But the judge is saying, listen, you know, they didn't litigate in bad faith. Now, and it's different than what he's saying. That's like they were ultimately unavailing, but it doesn't mean that it was brought in bad faith. Saying that, you know, they're bringing it in their home state is where they would normally bring something like this.
Yeah.
Now, if they were an attorney would have said no.
Yeah, and they also have to, because they're trying to go after the lawyer. The lawyer, you know, isn't going to do something ethically wrong. The lawyer generally tries not to do it. That's why Sarah has lost a lot of lawyers, because she was trying to make cases that have no ethical or legal standing.
Right.
So a lawyer is generally not going to do something that they know is ethically wrong.
Right. And attorneys will have the ability to fire you as a client. And you know, whenever I worked for Geek Squad, I had this lady that, you know, wanted me to work on her computer, and I was just like, absolutely, you know, this is one of those kinds of things that we do whenever we go out. Customer hires you to work on their computer, and I sit there with her and I explained to her that, you know, I think the time she was running a Windows 95 and Windows 8, I think it might maybe come out at the time. So, you know, the hardware couldn't sustain what she wanted to do. And I explained this to her. She was like, well, I bought this new version of Windows 98. I said, yes, but your computer's going to run really slow. I said, you know, I can still install it, but, you know, it's going to have a lot of problems. You also don't have enough disk space here to handle the workload of what is going to be happening. So you're going to have to do all of these things. After all is said and done, you're looking at basically buying a brand new computer, you know, and on a machine that's not going to last you but maybe a year or two. I said, it might be more efficient if you went and got a new computer, and that way you don't have me working on this and installing that. She was like, nope, absolutely, I want to have it all installed. I don't care. I was like, all right. Installed it all, and it ran like crap. And then she wanted to complain that it ran like crap. I was like, listen, I already told you ahead of time that it was going to run slow because this is much more demanding than the system that you have. But it cost me X amount of dollars. I told you that at the very get-go. You agreed to it. See your little signature here? See, I was very meticulous on this kind of crap. And then she started cussing me out. Well, whenever she started cussing me out, I just turned around, packed up my bags, and walked out the door. And then she called my boss, and my boss called, well, my store, because I had a manager that worked at the store. I had a manager for Geek Squad. Then it calls him, and he was just like, what are you doing? You can't just walk out of a customer's home, blah, blah, blah. I was like, I'll eat the money, but nobody talks to me like that. You can't sit there and cuss at me and call me a piece of shit and a son of a bitch and all that kind of stuff, because I wanted to slap the ever living shit out of her. As a human being, you just don't talk to people like that. And and he was just like, oh. I was like, I've got no problem. If somebody wants to come back out here and finish it and they can collect the money off of it. I haven't collected any money. The equipment's still in there. I said, but if I don't walk away from this lady right now, I'm going to say something that will get me fired. And I've been very constrained. He went over there and dealt with her himself. And, afterwards he was just like, yeah, there's no way you're ever going to get fired after dealing with her, because she did the same thing to him.
Yeah. Well, and you get people like that. And that's the thing. While, Shakray Cray and Jeff may have filed this to bring the pain, the lawyer acted within the bounds of the law. They can file in their own state.
Yeah.
Now, it does look like they did it a lot in bad faith, and the judge did knock them on that. So that's probably not something they're going to repeat again.
Right. Yeah, and that's probably why we haven't seen them file any more lawsuits in these. Like, these are the only two lawsuits that came out of it. And that literally is the final outcome of that. Basically, the case was dismissed, but now they're looking at issues with criminal court.
And Shizzy and I are saying we're going to probably be another year. Right now, they're going through everything, especially if this is international. They're having to get all of the search warrants. I mean, we've gone through Brian Koberger and seen all the search warrants that they had to get just for that. So if it's international, if they've got the terabytes of, the back hardware, the hard drives, I'm always like, what's that thing that she had that she plugged into her computer? Oh, the hard drive. So it's going to be a while. I mean, justice runs really slow because they have to do everything by the book.
Yes.
So we're probably not going to hear much more about this.
Right.
For a while.
And but that doesn't mean we're going to stop talking about different cults, because we've got more, and I've got some that Mo's never even heard of before.
I know.
And so she gets a nice introduction into some of these, and we may cover a few of them at a time. And we'll probably talk and discuss what exactly which ones we want to cover. I mean, we could go over like the Branch Davidians and stuff like that, which I've talked about before, which are really interesting. Just especially the conversations. I think we'll probably stay away from John Todd, except he might get thrown in there whenever we talk about Ruby Ridge.
Yeah. Well, the two things that made me hate the ATF,
Oh
Waco
God, yes.
and Ruby Ridge.
Yeah, both of those will make you hate the ATF. But if you understand what was happening at the time, which I was a little more aware of it because of my age.
I was a little bit like 9. I was just like, I don't understand what's going on here, but who's that dude that leads the FBI? And my mom was like, that's a woman. I'm like, no, it's not.
Yeah, this is Janet Reno. Oh my God. She was so horrible.
Oh
I
my
mean,
gosh.
and I did
She,
not agree with the way that they went about it. It was completely improper. Okay,
well,
in my
no.
opinion.
Well, that and the fact that they had David Koresh under surveillance for
Yeah,
months and months, and he would walk down to the local, I think, somewhere local, either because, okay, if you're in rural places, the gas station is also the post office and the Kenny Rogers Roasters where you get your fried chicken
yeah.
and possibly the bait shop. So that's what our local gas station is, also the post office where you get your bait and also where you can get some really good fried chicken.
Well,
So,
and because there was also a lot of other things going on politically at the time. And so, I mean, I understand why they acted the way that they did at the time because there was things that we didn't know about that was happening
yeah.
in the world of politics. Just because we didn't have as much stuff being FOIA'd as it is now. It's the same way if you look at those guys that were in that court case for the assassination attempt on Governor Whitmer,
Yeah.
that they were adjudicated of because of whenever you've got 6 people sitting in a car and 4 of them are feds, that doesn't look too good. And
No.
it looks like you guys were running the show because these guys were just sort of like, okay, sure, we can go, but we don't know how to plan this, and these federal agents are planning everything of where they're going to
Yeah.
go, how they're going to do all this stuff, and the court sees this and they're just like, you're a jurist and you're looking at this, a member of the jury, and you're just looking at this going, you've got to be kidding me. Why did you even bring charges against these guys? Because clearly they had no idea what was happening.
No. And that's the thing. I think that we're going to get a lot more, and I can foresee there needing to be kind of oversight things. That's the problem with the FBI, DCYF, basically any of your letter agencies. They don't have oversight. They're allowed to tell Congress, we've redacted this.
Right.
We've redacted this. Not that I want Lindsey Graham or Chuck Schumer to be anywhere near state secrets,
No,
but
but
still.
the and it's odd where a lot of those redactions come in because the same way there's you put a light on it and it can show what exactly is going on. And then also, I understand why they do redact it because you don't need someone harassed. I mean, what was it? Whenever Gorsuch and
Gorsuch.
yeah,
Yeah.
we had Supreme Court justices that there were people threatening to delete them,
Yeah.
and showing up at their places of where they live with their kids being there and threatening these kinds of things, and that's not acceptable. You know,
No.
and so I understand why, yeah, you want to redact, the judge's address, that kind of thing. But, or if there's kids involved or somebody
Yeah.
that's, uh, could, a woman that might be, having a stalker that, finds out her address because he was reading a court case that she was involved in. That's why we
Yeah.
have Jane Does and John Does.
Yeah. I mean, and that's the thing. So we are going to be waiting for this. We haven't, forgotten about Twin Flames, but we're going to go to other cults because there's a couple of them out there, like 4 or 5 or billions.
And then Mo's got a few for me also, like stuff that was it Daybell or something like that you were covering.
Oh, oh
That I
yeah,
never,
their cult. Oh, good Lord.
yeah,
Yeah, I have to do some research on that because they're crazy in a handbasket. Like, all the crazy, like portals in your closet, past lives. I mean, I gotta hand it to Lori. Every lifetime she picked old Chatadias. She's like, it wasn't like Mark Antony or, Galileo. She's like, no, the guy over there that looks like a thumb. Yeah, no, he's my guy. Chatadias, Chatidis.
He rocks my skirts.
Yeah, oh my gosh, and they have the worst romantic Mormon friction prawn.
I don't know anything about
There's
that. That
there's
sounds
a lot
weird.
of like rubbing against each other with like 8 layers of clothing on.
That sounds like a furry.
It- yeah, well, it's Chad Daybell. I don't really want to think about him getting all loin fiery.
No, no, I never like to think about that kind of stuff. No,
No.
no. But yeah, so twin flames is something that initially brought us together on this kind of stuff, and there are plenty other cults. I've had somebody reach out to me that said that they would be interested in coming on and talking about a very well known thing that they consider a cult just because their minister was. I I'll have to talk with Mo on that because that's
Okay.
something that we, I don't generally just bring people on to bring people on. I usually like to vet things out a little bit more because my channel could easily get deleted because
Yeah.
of something that they don't that they're, and it's not that they would do it intentionally. It's
No,
just they
but
just don't
yeah.
understand how YouTube operates and the kinds of things that they like to throw at you whenever you're not suspecting. Like, uh, should I show them the video of the Christmas bells?
I
No,
would
I'm not
wait
doing
for
it.
Friday.
No, because what I'll do is I'll put it like I'll record it and then put it in the background, see if it gives me a copyright. If it does, then I won't do it. That's if I
Probably a good
remember.
thing.
That's if I remember. Um, howdy, Mike Morgan. Howdy, howdy, howdy.
Howdy,
Uh,
howdy.
and Sandy says she's catching up with us. So is Mary. And
Oh,
oh my
cool.
gosh. I mean, all you wonderful people coming in here and
Yeah.
checking this out. Because this is something that like Mo and I talked about at the very beginning. We were doing this on a regular basis every Monday. But as we're starting to get closer into the holidays, it gets
Yes.
it gets a little bit tighter, and then you've got other cases that we're covering and plus family, and we'll start getting really tired really quick. And
Yes.
there's only so many hours we can do a day.
Yeah. That's kind of the thing. And as much as it looks like we're just two jackasses, having fun on the internets, we actually, I know this is going to be shocking, but we actually do try to put together a semi-coherent stream for you guys
Yes.
prior to, despite all evidence available to the contrary. We do
Yes.
attempt to be semi-professional.
Semi, like more like an 18-wheeler driving through the middle of
Look, it's
town,
a half chub, but we attempt to be fully,
fully erect in
professional.
this.
Yeah, fully upright and erect in our dedication.
No, but and then of course we've got Coburger that we're also
Yes.
going to cut that down to once a month. So it'll be every 2 weeks. And
Yeah.
we'll alternate between those Mondays on here once a month, Wednesdays over on Moe's once a month, and you'll see those
Yep.
every 2 weeks. That gives
Yeah,
us
and I'll
also
try to be good at, like putting up a warning thing in theory.
in
In
theory.
theory.
Well, and also if because those might fall on holidays or around holidays, we may just decide to do like you might see one that we do at the end of the month, and it was such like there was something that we couldn't get to, so we decide to do it the next week or something like that
Yeah.
because the rest of our schedule is going to be filled up for the month. So don't be surprised. Just you make sure you're subbed up to us so that way
Yeah.
you get the notifications.
Yeah. Again, in theory.
That
YouTube
well, and
has notifications now. It's an amazing thing when they send them out.
Well, whenever they send it's funny because I get notifications like 2 or 3 days later. I've got them as far out as a month. It's like I saw what was it today? It was Tugs going live and and it was like 4 months old. I was like, what? I was like, I don't know anything about that. I was like, that was 4 months ago. I think I probably already heard about it or saw it. It bears no relevance on anything that's happening right now. So, but yeah,
Yeah.
so just be expecting to see us, and of course we do have our regular Friday that
Yeah.
we do over on Mo's channel in the morning, and then we come over here and we do a pre-stream on Fridays. And
Yep.
if you don't see it happening, it's only because one of us came up with a reason for it not happening.
Yeah.
Like I think in November, most likely I won't be able to join on Friday or Monday the first couple of weeks because I've got
Okay,
a couple of
yeah.
things going on. But still keep me in mind because I may be able to, although I'm going to be in a remote location, I still may have access to a computer and I should be able to join on.
Shizzy's going to space. He's riding Elon.
Pigs in space. I remember the Muppets, man. That was so awesome. So
I
yeah,
love the Muppets.
oh god, they were just such a blast. I mean, especially the old crotchety men sitting up there.
Those are my favorite. Like, that's who I wanted to be when I grew up. I was like, how do I skip this whole adulthood thing and get to the crotchety old guy making fun of people?
Oh god, yes, that would be the best thing if we could get those. Oh man. And if you're wondering more about the Disturbed stuff, we actually did cover those, but those are you'll only find on Rumble. The
Yes.
documentary portions of it, only you're going to find those on Rumble. YouTube is very particular about what they'll copyright, and I didn't want to disappoint people by having my stream like right in the middle of it, like cut off every
Yeah.
15 minutes as we're trying to go through it.
Yes.
So it was somewhat intentional, and I thought I had something here I wanted to show you really quick because it was pretty damn funny. I saw it the other day. And it is, I just want to make sure I have the right thing. Okay, here we go. I think this is it right here. This is this I saw this and I was like, I thought, oh my god, I've got to show this to Mo. And it's not really a Friday thing. It's a time filler.
Okie dokie. Okay. Are you listening to it? Because I'm not hearing it or seeing it.
Oh, hold on. I'm sorry. It was I got blank on you because I wasn't sharing my screen.
Oh.
This is good.
I've been wanting to try this place for so long. It's
No,
like,
yeah, no, it's a
looks
great
so
spot.
good.
Yeah, I'm sorry. What is that you do?
Oh, I'm an accountant.
No, I mean like the weird voice thing.
Oh, no, I'm sorry. Yeah, I'm possessed.
Sorry.
Is that a problem? I swear to God, I'm like super normal besides that.
That's fine. Yo, what?
Sorry. What did you order?
I knew you'd like that. Here it is.
Mr. Mo just has to worry about me making puppets. Honestly, he shouldn't complain.
And I should.
Other than that, I'm super normal.
Oh, I really wish this wasn't parody because it's so funny.
Murder. I hereby sentence you to 2,500 consecutive life sentences plus 1,000 years. Once you pass away, you will receive an attempted escape charge with an additional 200 years being added to your sentence, which you will begin serving in the afterlife once you get to hell. Should you be reincarnated after your death and return to Earth as another person, you will be arrested at birth and you will spend your entire next life in the state penitentiary.
I'm kind of okay with that. To be honest, that's how I'm going to do every single one of my court cases.
I thought it was glorious, and that's why I had to show it a second time. Most Friday weekend roundups with Shizzy are awesome. I know we have
Yes,
such a
they're
good
awesome.
time, and Fallstorm comes in whenever he's able to,
Yeah.
and just really it's a well-rounded Friday.
Yes, it is.
Because it doesn't stop for us, because we do that and then Mo runs off and actually like gets something done, and then we come back on the evening, and then we go over and harass the expert for an
Yes. And if you guys need to watch a stream where no one has any idea what's going on, but we're all laughing about it, this Friday's FNL was chef's kiss for hilarity. Like, we didn't even get on the rails to go off the rails. We were never even near the train depot anywhere.
No, I can't think of a 1 second that we actually made it to the stories.
No.
Yeah, it was pretty solid. And I will say that whenever I was on with Tug, what was it, Saturday, there was so many cases that we wanted to talk about and show, but we never did. Like, because we talked about it briefly. He goes, yeah, I want to sort of cover this right here. And I was like, that sounds great. Let's go ahead and do it. And then next thing you know, we're just like having a conversation like we are right now for like 2 hours.
That's every Friday night in the green room after the stream. Okay, guys, I need to go, or we're going to wake up. It's going to be 3 a.m. and we're going to look at it like, because we all have ADHD and then we forget that we're supposed to be leaving.
Yes. Yes. And and here's the thing. It's 1:40, but I think I've got time for one more to show you guys, because I showed this one on Friday. So good.
I got my coffee. I want you to test out your new mug. Here, open this up. You just pour your coffee in that mug.
Damn, coffee cost more than the mug.
And tell Ruben how much you appreciate him.
Not worth a fuck.
Hold on.
A fucking dollar fucking mug, coffee cup, and we got to buy the fucking coffee to go in it, and you didn't put a damn thing in it. You could have put something in the damn thing. Ain't that shit hotter than a motherfucker, man?
You like your mug? Look, it changed colors.
Son of a bitch.
Turn it around.
You son of a bitch. You and Ruben, fuck you and Ruben. Both of y'all dog good, ragged ass motherfuckers gonna send me a fucking cup with a motherfucking man on it. You ain't shit, Ruben. Son of a bitch. Man, that don't make no damn sense. Who the fuck y'all take me to be?
Well, that's Ruben right there.
Put that motherfucker back in there and send it back to Ruben. I'll be fucking I'm drinking out of it.
It's like my grandfather. I swear to God, same damn attitude, same short, like.
Everyone knows this guy. Everyone's either worked with this guy. This guy's your grandpa. Everyone knows this guy. That's why it's so funny.
I know. No. Oh, like. I'll tell you a joke later. It's pretty bad. Everybody have a wonderful Friday or Monday. God,
whatever day is today, it's 2025. You get to choose what day you identify as being in.
And go show Ty a little love. And Megan is going to be running a stream tonight with Tug. I'm sure there's going to be some documents that come out. I may do a stream later. I don't know for certain. I haven't had a chance to read over any documents, if anything's been filed. everybody, just be kind to one another,
Yeah.
and we'll see you again on Friday. Just
Yeah.
Mo and I, and maybe a few others. Peace, y'all.
Bye, you guys.